my dear students. In this lecture, we are going to discuss the foundation, or you may also call it the basis of tortious liability. After going through this module, we should be able to elaborate the theories regarding the foundation of tortious liability. We must be able to explain whether it is law of tort or law of torts. Number 3, to try to understand the difference between tortious liability from other civil liability. To briefly analyze the general essential prerequisites which are the foundation of tortious liability, and to know the role of courts in imposing the tortious liability on the tortfeasors. Dear learners, you must be aware about this fact that there has been some controversy as to the question upon what principle does the foundation of liability in tort rest. In other words, whether it is law of tort or law of torts. To answer this question, two competing theories have been propounded. According to one, all injuries caused to another person are tort unless there is some justification recognized by law. This theory was propounded by Sir Frederick Block in year 1887. According to Sir Frederick Block, this branch of common law is known as law of tort. His theory was supported and accepted by Justice Bowen in the case of Skinner and Company versus Shaw and Company, while observing that, I quote, "At common law there was a cause of action whenever one person caused damage to another willfully and intentionally without just cause or excuse." In another case, Justice Holmes observed that it has been considered prima facie that intentional infliction of temporal damage is a cause of action, which as a matter of substantive law, whatever may be the form of pleadings, requires justification if the defendant is to escape. The theory was vehemently supported by Professor Winfield in an article which was published in year 1927 in leading journal Columbia Law Review, and later on in his books. There were other supporters as well, which include Dr. Allen, William Holdsworth, and so many. The other theory suggests that it is a definite number of torts outside which liability in tort does not exist. According to this theory, an injury can be tort only if it can be fitted in principles governing any particular tort which stands recognized by law. The second theory was propounded by Sir John Salmond. This theory is also known as Pigeonhole theory. For Salmond, it is law of torts. As per his version, the liability under this branch of law arises only when the wrong is covered under any one of the other nominate torts. In other words, there is no general liability, and if the plaintiff can place his wrong in any of the pigeonholes, each containing a libel tort, then he will succeed. His theory has been supported by many, including Professor Jenks, Dr. Layton, John Miller, and others. Because of difference in approach, Professor Winfield's book on the subject is entitled as Law of Tort, whereas Salmond's book is titled as Law of Torts. Dear students, if we analyze both the theories, they have their own implications. These two theories have different implications. If the first one is accepted, the courts have full power to create newer torts, because every injury is a tort unless there is some legally recognized justification for causing it. Whenever a new type of injury comes to be decided before the court, it can give remedy for it. The implication of second theory is that according to it, there are number of recognized torts. If any injury comes to the court for decision, it can provide remedy for it, if it can be fitted in the framework of any recognized tort. Some observe, I quote, just as criminal law consists of a body of rules establishing offences, so the law of torts consists of body of rules establishing specific injuries. Neither in one nor in the other is there any general principle of liability. Whether I am prosecuted for an alleged offence or sued for an alleged tort, it is for my adversary to prove that the case falls within some specific and established rule of liability, and not for me to defend myself by proving that it is within some specific and established rule of justification. Professor Winfield, in his essays on foundation or liability in tort, tried to establish the supremacy of the general principles of liability over Simon's pigeonhole theory on the ground of certain propositions. That includes number 1, mere novelty has never been a conclusive objection to the judicial recognition of any new remedy in English law. Number 2, mere novelty is not a conclusive objection to judicial recognition of an action in tort. To support these propositions, Professor Winfield traced early development of law of tort by invention of new or similar torts by the courts. He then cited some specific cases, for example, Hunt versus Damnum, Bodily versus Long, Starling versus Turner, Morris versus Slew, Smith versus Crenshaw, and many others, in which the courts dismissed as useless the contention that the action was a new one. Then he goes on quoting some authoritative writers, including Blackstone, Lord Bowen, Mansfield, and Holmes. And ultimately, he cited some instances of torts which have emerged, for example, tort of deceit. In year 1789, in Parsley versus Freeman, the rule of strict liability, which was laid down in Rylance versus Fletcher in year 1866, and so many other rules like occupier's duty towards inviting. The courts have the power to create new torts, or at least new remedies for tortious injuries. Whether they will create them or not is a matter for their judicial discretion. Most of the torts are subject to what Frederick Locke has happily described as general exceptions from liability, such as act of state. Each specific tort has ingredients which must be present if the plaintiff is to win his case. He will lose if, for example, in defamation, the defendant proves privilege; in false imprisonment, if the defendant proves lawful arrest; in deceit, if the defendant's statement was merely negligent. There is nothing like an exhaustive classification of torts beyond which the courts should not proceed. New invasion of rights devised by the brain of man might give rise to new classes of torts. The court held that malicious procuring of house search does not constitute a tort. Now we will move to conditions or essential elements of tort. A tort can be defined as a civil wrong which is redressable by an action for unliquidated damages and which is not merely a breach of contract or a breach of trust. In simple words, it is a civil wrong independent of contract, giving rise to civil remedy for which the compensation is recoverable. It's an act or omission of an act that affects the person's legal right. Now we will try to understand the essentials of tort. Number 1, wrongful act or omission. In order to constitute a tort, there must be an act performed or omission of an act on the part of defendant. Act performed or omission of an act should result in legal damage, that is injuria, which means the violation of legal right which is vested with the plaintiff. In order to make a person liable in tort, it is necessary that he must have done a wrongful act that he was not expected to do or omitted to do, something that he was supposed to do. When there is an act done by the person which is considered as wrongful act in the eyes of law, then the person would be liable in tort. For instance, if a person enters in the land of another unauthorizedly, it's a commission of an act, amounts to tort of trespass. Similarly, if a municipal corporation fails to maintain the constructions situated in the city, or if a structure is collapsed, causing death of a person in the surrounding areas, the municipal corporation is liable under law of torts for omission of a duty which they were otherwise supposed to maintain, and the same was held in the case of Delhi Municipal Corporation versus Subhagwanti. There is another illustration. Suppose a person publishes a defamatory statement against another person, and that too in public. In this instance, the person would be liable in tort under defamation who publishes a statement, defamatory statement. Similarly, when there is an omission of an act by the person which he was supposed to do, as that act was his legal duty to perform, then that person would be held liable in torts. For instance, person A fails to do a proper fencing around a poisonous tree to keep the children away from that tree. It was his legal duty towards the same which he failed to perform. And suppose a child climbs the tree, plucked the fruit from that poisonous tree, ate it and died. Here the person A would be held liable for omission in torts. But it never means that a mere social moral wrong that would make a person liable under torts. For example, a person would not be liable if he couldn't help a starving man, as it was his moral or social duty to help them, unless it could be proved before the court that the person was legally bound to provide such help. Number 2, essential is injuria, or you can say legal damage. It's important that plaintiff must show that there is a wrongful act or omission of an act that results in the breach of legal duty or violation of right vested in the plaintiff. Unless there has been the violation of legal right, there can be no action under torts. If there is no violation of any legal right, then it is not actionable in torts, no matter the plaintiff suffered any loss or not. The concept of injuria can be expressed through 2 legal maxims: injuria sine damnum and damnum sine injuria. Injuria sine damnum is a legal maxim, which means violation of a legal right without causing harm, damage or loss to the plaintiff. It's actionable without the proof of any damage or harm caused to the plaintiff. The only thing that is required to be proved is that there is a violation of legal right that was vested with the plaintiff. It simply means infringement of legal right without damage. In a famous case titled Ashby versus White, the plaintiff was a qualified voter in parliamentary elections, but the defendant, the returning officer, wrongfully refused to take the plaintiff's vote. Although no loss was suffered by the plaintiff because of the candidate for whom he wanted to vote won the election, it was held that the defendant would be liable under torts, as there was the violation of legal right that vested with the plaintiff. The Court of Appeal, through Chief Justice Holt, observed that every injury imports a damage, though it does not cost any party 1 farthing for a damage not merely pecuniary, but an injury imports a damage when a person is hindered of his rights. The Court of Appeal held the defendant liable to pay compensation to the plaintiff. The principle stated in Ashbury's case has been followed in India in its totality in the case of Kali Kishan versus Jadulal Mulik, and also so many other cases. When we talk of Damnum sine injuria, this legal maxim means damage without violation of any legal right of the plaintiff. If the act or the omission of the act causing damage to the plaintiff, but there is no violation of any legal right of that person, then the same is not actionable under the law of torts, although the plaintiff suffered injuries. There is a famous case on this point, that is Gloucester Grammar School's case. In this case, the defendant, the schoolmaster, set up a rival school near the plaintiff's school, and as a result of this, plaintiff had to reduce the school fees. By this, plaintiff suffered damage and loss, therefore brought an action against the defendant. It was held that although plaintiff had suffered the injuries, but since there was no violation of any legal right that vested with the plaintiff, therefore defendant was not liable for the damages suffered by the plaintiff. In yet another case, plaintiff was sued for the permanent injunction against defendant to restrain them from exhibiting the film, which was titled as Jai Santoshi Ma. It was contended that the film hurt the plaintiff's religious view, as goddess Parvati, Saraswati and Lakshmi were depicted as jealous and were ridiculed. It was observed that religious hurt has not been recognized as a legal wrong. Moreover, no individual can dominate their religious views over the other person and cannot restrain any person to do the lawful act. Since there was no violation of legal right that vested with the plaintiff, therefore the request of injunction was rejected and defendant was not held liable for any kind of harm suffered by the plaintiff. In yet another case, a famous case titled Bhim Singh versus State of Jammu and Kashmir. In this case, the petitioner was an MLA of J&K. He was wrongfully detained by the police while he was going to attend his assembly session. Moreover, he was also not produced before the magistrate within the reasonable period. As a result, he was deprived of his constitutional right to attend the assembly meeting. There was also violation of his fundamental right under Article 21 of Indian Constitution. By the time the petition was decided by the Supreme Court, the Bhim Singh had been released, but by way of consequential relief and exemplary damages amounting to 50,000 rupees, they were awarded in favor of Bhim Singh. If the court feels that there is a violation of legal right owing to mischievous behavior and malicious act, then the court may grant even exemplary damages. Number third essential, that is the legal remedy. As of now, dear students, we know that tort is a civil injury, but all civil injuries are not torts. The wrongful act must come under the category of wrongs, for which the remedy is a civil action for damages. The third essential ingredient of tort is that wrongful act complained of must be such that it gives rise to a legal remedy in form of civil action for damages. According to Justice Certifin, in the case of Breadloaf versus Gossett, where there is no legal remedy, there is no legal wrong. Further, the same is enshrined in the legal maxim ubi jus, ubi remedium, that is, there is no wrong without a remedy. Dear students, we may now conclude by saying that though there is no fixed general principle of which liability can be tested in each and every case, yet while creating new fields of liability and abolishing existing ones, the court does not proceed arbitrarily. Whenever a person suffers damage as a consequence of an act or omission of another person, the presumption seems to be in favor of liability unless the denial of remedy can be justified. The justification is not to be sought in law, but in public notions of right and wrong and the society's preparedness or otherwise to afford or deny remedy under the given circumstances. This seems to be the basis on which new torts recently emerged. New duties have been invented and consequently new fields of liabilities have been explored. For the same reason, the courts extended protection where it was once denied by abolishing the old and absolute grounds of justification. With this, we conclude today's lecture. Hope you understood well. Thank you.